thank you all for having us and letting us talk to you for a little bit. Susan did make this clear. We are not the comedians. So after a few minutes, when you realize we're not funny, please don't get up and walk out.
The legal analysis may be funny, but
so we're going to talk to you today about some corporate investigations and some government regulatory and investigatory matters that things that we see in our practice every day, things that are really very technical and we think of really high importance, and things that hopefully y'all don't have to face that often, but we want y'all to be better prepared and feel more confident when you do face them, that you know what steps to take and kind of an understanding of the framework. We also want this to be as interactive and helpful to y'all as possible. We're going to try to cover a fair number of topics at a high level, but if there's anything that you want us to delve into more specifically, or you have specific questions, even if it's not on a topic that we've yet covered, I would definitely encourage you to ask, especially with Christian and Jason, and you'll see why when I introduce them here in a moment. The fantastic resources, really top of their fields, and have a wealth of practical information in these areas, and I would strongly encourage you all to take advantage and maybe try to get some free legal advice out of them. So my background as an employment lawyer, I'm the chair of the U.S. chair of the employment group at DLA. So that's the perspective I bring to it. Christian has a phenomenally impressive background. I won't go into the whole detail of it, but he joined us as a former federal prosecutor and senior official from the Department of Justice in the Counterintelligence and Export Control Section. Before that, he was a Deputy Assistant Attorney General in the Office of Legal Policy and an Associate Deputy GC for the DOD. Before that, he also has multiple graduate degrees in addition to his law degree, and then before that was also a Navy SEAL. So if anyone's thinking about rushing the stage tonight, you might give that a second thought. Yeah.
we don't need to talk about my bio. It's okay. Let's move on.
Jason is a really nice guy, and we like having him here. Jason is an extremely accomplished securities litigator. He was a senior enforcement attorney with the SEC. He's chambers ranked in white-collar litigation investigations, recognized by GIR, which is a very select recognition that only a few individuals in this field have, and just a very accomplished, top of his field, and a really fantastic lawyer as well. So we're going to talk a little bit about, like I said, investigations and some of the regulatory framework, but we wanted to start with just kind of an update on some current trends that are going on in this area, just to set the stage a little better. And so I'll turn it over to Christian to address that.
Yeah, thanks, Mark. So this is kind of a scene setter, just to kind of walk through, in particular with a focus on Department of Justice, what the Justice Department's focus has been in the area of corporate enforcement. And so going back to Deputy Attorney General Sally Yates, 2015, kind of start the story there. There was a point at which DOJ made a decision to start focusing more on individual culpability in the context of corporate crime and enforcement. And so there was the Yates memo was issued that laid out some of the details of that. And the effect of that memo, and the changes in DOJ focus is really difficult to quantify. When you look at, for example, FCPA cases, the following year there were about 10. Looking at the larger context of how many FCPA cases were happening a few years prior, I'm not sure that was overly significant. But fast forward to the current administration, there was a reinstatement of that focus again on individual culpability when it comes to corporate enforcement. And there are some, and this was the Monaco memo that was issued in fall of last year. And there are some pieces of that particularly stood out. And one in particular is the focus on looking at corporate misconduct through a broader aperture. So it used to be that when DOJ was looking at enforcement and resolutions, and if they were looking at a corporation's prior history of misconduct, they tended to focus on similar conduct. And that fell away with the Monaco memo. And now they're looking at, for example, multinational corporations that may have parents, a number of subsidiaries. They will look now at the conduct or misconduct of those subsidiaries and factor that into any type of resolution and proposed penalty. So that's significant. The other piece of that is doesn't have to be similar conduct. So if a subsidiary gets into some type of regulatory trouble in a non-U.S. jurisdiction, they could, based on that memo, factor that in if another subsidiary or the parent is being investigated for other unrelated misconduct. So that's a significant change. An issue that was also included was on monitorships. I just want to flag one detail of that, which is that the decision of whether to use a monitor to make sure that a corporation is complying with the terms of the resolution is based on, in part, the state of the compliance program that the company or corporation was supposed to be implementing to resolve or address whatever the issue was that led to the misconduct. But the issue there is that they're expecting that the compliance programs will be completely in place by the time the case is resolved. And if not, then the idea is that they're going to be more forward-leaning about requiring monitors to make sure that corporations are, in fact, implementing and are following through with these compliance programs. So it used to be, at times, companies could say, we're working on it, we're doing a good job, we're almost there, we just need a little more time, and that's not going to be as compelling now as it may have been previously. Another issue that came up is the DOJ, not just the Deputy Attorney General, but other senior officials, have been talking about corporate crime as having an increasing national security dimension to it. And it's kind of, when you hear that, it's like, well, what does that mean exactly? That could mean a lot of things. And I think what it means is that a major change and a major focus now from DOJ's perspective, and actually the whole of government, is economic sanctions and export controls. That is an area that's dynamic. It's constantly changing, and it's not just the Ukraine war that caused those changes. It's been in the works for many years, and it's now, sanctions are now a preferred tool of foreign policy. And if you are tracking what's going on in sanctions, if you have a job that requires you to keep track, there are a lot of programs that are changing. People are being placed on the sanctions lists. And so corporations, companies are increasingly facing exposure, in part because of this increased attention. And to the extent that they have some exposure in a supply chain, this is something that they need to be considering, because the resources DOJ is throwing resources at this particular issue. And so that's something to be thinking about as well. And the sanctions are, by definition, a national security tool. So I think that's what the connection is with corporate crime on that front. Some other things that are happening as well. There was talk of, and actually they're beginning to implement this, that as part of, for example, under a resolution having the corporate compliance officer certify at the end of a probationary term under a deferred prosecution agreement to certify that the compliance program is up and running and essentially is good to go. What's interesting about that is that the head of the CRIM division recently made statements about how this is a great thing because it empowers corporate compliance officers. And I don't know if we have any compliance officers out there, but I don't know if you would feel that empowered if you had to file a certification that a company's compliance program is good to go with the government. But that's one of those requirements that they're also batting around as well. There are some other developments as well, but I think I'm going to, for the sake of time.
Yeah, and I think to add on what Christian talked about, the resource issue seems to be, that's why I think spending time on sanctions is important, because the resources are going there. The other two places where we're seeing the resources going are obviously both a little bit in the Home Office and of the DOJ Main Justice, as well as the U.S. Attorney's Office in D.C. are going a lot of resources to the January 6 issues, and then the Healthcare Fraud Task Force is very robust and has folks scattered among the regions. So what I'm seeing, and I think in addition to sanctions, you're seeing a lot of resources going to those other areas, which means you can infer that some of the other things that are going on aren't getting as much attention. And so that's why I think focusing on sanctions, probably with some of the things you see, there may be some healthcare compliance or in-house folks here. There still is a very big emphasis on healthcare at DOJ, and the task forces are very, very aggressive.
And on the sanctions piece too, to go to your point about the resources, I mean, it is somewhat zero-sum. There may be people out who've worked at U.S. attorneys' offices as AUSAs. You know that most offices, especially in the jurisdictions that are going to handle sanctions, are extremely busy, and they're working long hours. In the case of the cases you mentioned, and the cases of sanctions, they've set up the task force at Main Justice, so that is a signal that it's a priority. So they're actually designating people like January 6th. They're taking people out of the general pool of prosecutors, and they are focused and committed on that particular area. And when the department does that, it's a credible signal that that's a focus. And I think that you'll see, if you track some of the sanctions and export control prosecutions in the next year or two, I think you'll start to see a lot of activity there. And some of these, most of these investigations take a long time, but I think there will be an uptick based on the amount of resources they've committed to that particular area.
So we can talk briefly about SEC enforcement priorities and trends. I know there's a lot of CLEs out there. David Peevler shows up at a lot of things and talks about SEC priorities and what the Fort Worth Regional Office is doing. Having a robust, really good office with a lot of good people in our region, it's a good thing and a bad thing, I guess. There's a little more scrutiny on Texas companies, and Fort Worth has really great folks investigating and doing their job, and they're actually one of the easiest offices to deal with. They're very practical, and they have a lot of longtime career folks that are still there. So it's kind of a double-edged sword for companies here, because you are close and you have a robust office, but at the same time, I think they're a fair office. I was just going to walk through quickly just so you can see. I think the SEC enforcement trends are not going to be favorable to the corporate environment. I think robust enforcement is back. I think we're going to be back to Obama administration robust enforcement. It's going to be tougher to settle cases favorably. It's going to be tougher to exclude individual liability. There's really an emphasis on actual individual corporate wrongdoing. So the days of just bringing a case against the corporation and leaving either the gatekeepers or the officers out of the mix are going to be few and far between. I'm already seeing that, where although there are some reasonable staff attorneys out there that are trying to resolve matters without adding individual culpability, I think we're going to see less of that. So that's something, as far as internal training goes, for those folks that are advising their officers and directors and gatekeepers, that there is this emphasis, and that and things are changing. And so compliance training, controls training, really an emphasis on getting disclosures right, making sure your press releases are accurate, you're not omitting things. I mean, this is going to be a very tightly regulated area, I think, for the next several years. So the SEC enforcement push I think is coming. I'm seeing the ramp up now. Just by way of example, through the first 8-9 months of the new administration, in 21 fiscal year, the SEC is on a September 30 year. They're not on the calendar year. So one of the things you do see at the SEC is a lot of cases brought or settled in September. So if you're following press releases or media, you'll see a lot of SEC either administrative proceedings or new cases filed or settled this month. So you guys can read the slide that's up. I don't have to read it to you, but it is really amazing if you think about it, that just by way of example, when I started at the SEC in 2004, I think our trial unit had not tried a case in 6 years in 2004, not one case. There were a couple of administrative hearings that lasted a day or two, AP actions, and we affectionately called our trial unit the settlement unit back then. That is not the case now. As you can see, there as of in 2021, 2,000 pending civil enforcement actions. I mean, that's a lot of cases, and then 1,200 administrative proceedings. And those that follow enforcement will know that, I mean, that is a large amount, and we expect to see more filed this month and then in the first quarter, which would be the fourth quarter calendar year. It seems that this robust enforcement is coming on strong. The director and the chair have asked for more funding from Congress. They want to add more enforcement attorney staff, more exam staff, and so again, just a fair warning. I think that you're just going to see more action. Doesn't mean that anybody's doing anything wrong or there's more wrongdoing. I just think that you're going to see more inquiries and more subpoenas coming down the pike. There are a few particular areas of focus that the Director of Enforcement brought up recently, being cybersecurity, digital assets. Some of you may be familiar with the SEC versus Ripple matter that's in the Southern District of New York. That is going to be maybe the new Howey test for crypto digital assets. So I think ultimately Treasury and Congress will make a determination on digital assets, crypto, and whether or not, who's going to regulate those and how they're going to be regulated. But in the meantime, Debevoise on the Ripple side and the SEC. Again, these are my thoughts only because I'm somewhat tangentially involved in that case. But it's either gonna be a very good thing for the SEC in that they're going to start regulating those digital assets and tokens, or it may result in the wild, wild west even more in that space if Ripple prevails, that their token and assets are not securities. Insider trading is making even a bigger comeback, and one of the things that might be important from an in-house or a compliance basis is 10b5-1 trading plans. They have become a very large focus of the commission. They're wanting new rulemaking to implement a 120-day bake-in period. What you're seeing, and there was a Wall Street Journal article about 2 months ago, a front page article about potentially companies taking advantage of 10b5-1 plans, noting that some folks even traded the day after they implemented their plan. That obviously is not the SEC's intent, and so something to think about, because I think it's coming, this 120-day bake-in period. So typically what I've seen in my practice, it's anywhere between 30 and 90 days is typically the internal bake-in period, even though there's not one. But I think really putting an emphasis on making sure that the employees, officers, directors don't have any material non-public information at the time they put this plan in place, and that they are allowing some time frame between when those trades are made. Even though it is technically out of their control, there is becoming some scrutiny, and I think what you're going to see in the next 6 months or so, or you're going to see some cases where the SEC pushes the envelope on 10b5-1 trading plans and brings some insider trading cases. So I think from a compliance standpoint, I'd really be looking at what you're going to do internally with regard to 10b5-1 plans. And I think figuring those out, doing them right, takes a lot of burden off the chief compliance officer or anyone that's having to approve the trades, to the extent insiders or Section 16 officers are having to get that approval when they're in trading windows. It would so doing a 10b5-1 the right way, doing the training, setting forth a big bake-in period would be something that I think with what's coming would be good advice to start working on internally. Gatekeeping, usually in-house folks don't want to hear that they're looking at gatekeepers, but there is more of an emphasis on gatekeepers. There was a time when chief compliance officers or general counsel or outside counsel definitely got a pass. They never were at the front and center of investigations, but you're seeing more and more of these folks having to testify, getting document requests themselves. So just again, back to compliance officers having to certify things, just to be on the lookout, and not trying to scare people away from being a gatekeeper. We're all gatekeepers in some capacity, but there is going to be more of an emphasis on those that are circumventing internal controls or doing not taking the proper steps. So another just practice tip to be on the lookout for. Also, just to give an example of how robust things have changed, I have an investigation that I'm working on that dealt with a restatement issue, and it was being handled out of the Fort Worth office. I get a subpoena, my client gets a subpoena 2 months later from the home office on a separate issue. I've never seen that. They combine the two investigations into one, but I have parallel investigations from two offices into two different issues under the same investigation for one company. So I've never seen that. I've been doing this for a long time. I've never seen the commission do it. And in fact, early on, they weren't even talking to each other. They weren't even, so I was having to figure out, I'm producing documents to one side. Can I wait on yours? Who do I go to? Who's running it? And so that's just by way of an example. So again, something I've never seen, that two separate offices conducting a parallel investigation into one company. So again, not trying to be the bearer of bad news or frighten anybody, but I think that more intense, robust investigation is definitely seeing that now, and I think we're going to see a little bit more of it in the next probably 6 to 18 months from the new commission.
Thanks, Jason. I'm going to switch gears just a little bit. As you can probably tell, so Christian and Jason deal with issues when there is a problem or there is a potential problem, or you're trying to make sure that a problem doesn't arise. And I do think using lawyers like them on the front end for compliance issues makes a lot of sense to avoid a lot of pain on the back end. When I get involved on the employment side is typically, in these matters, is typically when there's a report, an internal report of a concern of these issues. And so that's when I get involved to try to walk folks in your shoes or your colleagues' shoes through how to do the investigation. And so, I think it's always good at the outset to keep in mind what you want to accomplish through an investigation. I remember when I was a little kid, I used to talk to my dad all the time, and he would always respond, it'd be really helpful if you had a point. And that's the that's the mindset, I think, towards the investigation is you want to do the investigation in a very systematic way, so you can make sure you achieve your goals. And then the first step there is, of course, to identify the goals. So I've listed out the ones that I recommend to clients to make sure that folks in your shoes that you're thinking about. First is to identify, whether there is an actual issue or potential issue, and ultimately you want to fix that if there is. Now that's where Christian and Jason come in to help on that front. You also want to make sure that your clients, and part of this is identifying who your clients are in the situation. Is it the officers? Is it the board? Is it the company generally? Is it a situation where there needs to be an independent board or an independent group of directors? You want to figure that out. You want to make sure that those folks are not getting dragged into any potential liability. And you want to take those steps. You want to document effectively the good faith steps that you've done. One thing that always makes these situations very challenging is the timing. They're usually immediate, and you have, and Christian and Jason are going to talk in a little bit about disclosure obligations, which come hand in hand with those, and it just puts a really tight time frame on there. And then you want to figure out where you want to look, who you want to talk to, all those sorts of things. And the bottom line, the point, I guess as my dad would advise me to say, the point is that you've got a lot of competing things that you have to make decisions on how you are going to address them, and you've got to think about those most often on a very time-sensitive matter. And so you want to lay those out in the front end, and that's why to do the shameless sales pitch, it's you want to have lawyers like Christian and Jason who know this. They know the law, they know the regulatory environment, they know the potential enforcement entities and the prosecutors, and can help walk you through those kinds of things. And then when you do the investigation, obviously it's sort of similar to that. You want to plan the investigation in first, and the key is to make sure it's objective. I tell clients all the time, it's almost always better not to do an investigation than to do one that's biased or has got subjective. And there's frequently, almost always, some subjective element. And when you make findings, for example, or recommendations, there's an element of subjectivity, but make sure that you have a foundation, a basis for those conclusions. And that does take a level of objectivity to it. I always say you want to, another way to think about it is you want to avoid doing what's wrong. And so a lot of this is somewhat common sense. You want to take a rational and reasonable approach. If you don't know what's rational and reasonable, find somebody that's rational and reasonable and get their input. But again, it's tricky because of all the moving parts that come into these situations. But I find that the best way to do this is to lay out the framework on the front end. You get the buy-in approval from your clients on the front end, and then you can do the more quote-unquote objective investigation wherever that leads, rather than just diving right in without a plan and getting twisted around and getting results that get you in more trouble. I think Christian's going to talk a little bit about, this is part of the investigation process, about some data privacy issues when you're gathering information in these investigations.
And Mark, before
Yeah.
you go there, I think going back, the scoping issue is super important. As someone that does special committee and audit committee investigation and internal investigations, is scoping and coming up with the framework. Mark's exactly right. I mean, you've got to figure this out on the front end, what you're actually, the scope is. And I've experienced this where I've either represented individuals or the company where somebody's doing the independent investigation, and there's so many tentacles, it's going everywhere, and the company is just kind of floundering. So putting together a scoping document for whatever that may be, it might be a special litigation committee on a derivative demand, it might be an audit committee investigation, but coming up with exactly what you and the company can agree on is the universe of what you're looking at, because at some point a law firm or anyone else can you keep turning over rocks and the investigation never ends. So it is really important to do that on the front end.
So Christian, I think,
Yeah.
is going to talk a little bit about data privacy.
Yeah, and just to that point, talking about picking things up, going back to the sanctions and export control investigations, just because of the nature of those types of violations, they typically involve multiple jurisdictions. You tend to, and there's some compliance issues that are closely following the investigation unavoidably. It's not unusual, I'm talking about scoping the investigations, to start picking up other violations as you're moving along. And so you have to go back and recalibrate at times and make sure that those are taken into account as well. On the data privacy, the reason I want to bring this up is just, and I'm looking at it from the perspective of, somebody who's been brought in to lead or assist with an investigation, particularly an internal investigation. And for those of you who've had the opportunity to be involved in that process, you may have already learned that the data privacy issues, in particular with GDPR, are tricky, and you need to keep a close eye on them, just because you're going to have to do a risk balance analysis based on whatever it is you're investigating. And so just wanted to flag, the types of things you need to be thinking about at the onset of an investigation. Once you kind of understand the nature of the possible violations and scope, and you have a sense of what type of data files, custodial files you may need to review, you need to get on the phone with the IT folks to understand where data is being stored. It's not, obviously in today's environment, it's not unusual, especially for multinational companies, to have subsidiaries, particularly in Europe, have a US footprint, but then the data center that stores the data that you need to gain access to is somewhere in the Middle East. And so you have to work through, what from the GDPR perspective, what the risk is there of processing that data, which means you're pulling that data in. Sometimes you may need to consider setting up a team in another jurisdiction that is reviewing, in particular Europe, that's going to review the data, do a first level review before the US team gets involved. But this is something that you definitely have to kind of work through ahead of time. There is obviously, depending on the severity of the potential violations, again, you're doing that risk analysis. But you also have to factor in the other jurisdictions. So from the US perspective, maybe the analysis makes sense, the processing to pull the data. There's risk there. You're taking steps to handle it appropriately. But if you're working with or in another jurisdiction, particularly in Europe, the penalties for violating the GDPR would be felt there more severely. And so where they could get regulators involved, have lawsuits, et cetera. So understanding kind of where the risk is there and setting up working with your data privacy experts, your data privacy counsel, to make sure that you're doing that appropriately. Because once you go down the wrong path early on, it's hard to unring that bell. And places to look. Want to know what's in the relevant employment agreements having to do that deal with the standards that are applied for sharing data across jurisdictions. Also, if you have subsidiaries, intercompany agreements sometimes will also provide some guidance on that as well.
Yeah, and that's just another example of what makes your job so challenging is these issues are very complex, and we often work together on these matters, and we work with our data privacy and sometimes our cybersecurity lawyers at DLA on this, because it just requires such a high level of expertise, and there's so many issues across the board in these matters. And I think Jason's going to talk a little about disclosures.
Yeah, I know we're jumping around a little bit because there's a lot of topics to hit, but I thought this was something that folks that do disclose or have investigations, governmental investigations, if you don't know about this case, it's going to be interesting to watch how it's dealt with. There is the Noto case, which was decided on a motion to dismiss, an appeal of a motion to dismiss in May of 2022, that basically kind of flipped the disclosure requirements of SDC investigations on its head. Now, a lot of folks are distinguishing this case based on the specific facts of the case, but there are a lot of folks that are worried now that what used to be the standard practice by companies, that typically until you get to the Wells phase of an investigation, there really was no duty to disclose that. A lot of my clients ask, I think it's about 50-50. 50% disclose when they get a subpoena, disclose the investigation, 50% don't. And the SEC's really never taken a position on the materiality of that issue, because you take the wording of their investigative documents, the formal order, their subpoenas, where there is no finding of wrongdoing at that point. So is there anything technically material to report at that point? But what happened in Noto, the Second Circuit found or held that the defendants had a duty to disclose the SEC investigation in light of the specific statements they made about the company's accounting weaknesses. In their filings, there was a material weakness related to their accounting issues, and they talked about it. And in the analysis, the court says, well, to make that issue not misleading, you should have disclosed that weakness was also being investigated. That issue was being investigated by the SEC. A lot of folks are distinguishing this on the specific facts of this case, because there are other issues related to the SEC investigation. In the underlying securities case, there are confidential witnesses who knew about it that told the plaintiff's attorneys. So then you have issues where there's disclosure out there versus remaining silent, which has been the ruling under Lionsgate in the Southern District of New York that most disclosure counsel rely upon. The Second Circuit also said that the existence of the investigation related to the accounting weakness, so therefore it was material information that a reasonable investor would have wanted to know. Again, anyone could argue that any investor would want to know any of the public companies they're investing in was being investigated by the SEC. That seems very practical and reasonable, but that has never been the approach, and the SEC has not pushed that issue either. One of the other facts in this case is that because they hadn't disclosed the case, and I've seen this situation occur, I've seen it occur on Kramer, on other CNBC, where they put an executive on the spot and the case has not been disclosed because they didn't feel the need to disclose it, or there wasn't a requirement to disclose it, or outside disclosure counsel said they didn't need to disclose it. So there's a public denial out there, because if whatever they say, you've got a subsequent disclosure issue that if you're kind of put in a box. So this is really interesting. I'm interested to see how clients are going to handle this case, public companies, how disclosure counsel, what the advice is going to be. So I think you're going to see and read a lot more about this case. I think right now the conventional wisdom is that this case is going to be distinguished on these specific facts, so people are going to operate under Lionsgate still, but we'll see if the SEC ultimately brings an enforcement action for companies that don't do it. So this is really an interesting case to follow. It's very new, and it happened so new to the second quarter. I'm not sure companies knew what to do, so seeing this third quarter and fourth quarter to see if companies subsequently disclosed existing investigations that they otherwise hadn't, it's going to be interesting. So just a case to follow.
Jason, with that one, did they ever actually bring an investigation against the company?
I'm not sure. I think it may still be ongoing. Yeah.
Doesn't the public accounting firms also have a concern with this? Because a lot of this, definition of what accounting weakness is negotiated or worked out to determine whether it is or isn't. And during that process, before it gets settled, you have a potential issue. And I would think that the Big Four, Big Eight, whatever they call it today, are going to have a vested interest as to this outcome.
I think so. I think most of, at least my experience with the Big Four, a lot of times they would rather the company disclose it anyway up front. Any SEC investigations, that's typically, I mean, they know Lionsgate, they know what typically happens, but that is a good point. And I mean, at the same time, that accounting firm may also be part of that investigation, right? At the same time, they may be being looked at as well on the diligent, how it got to that point, what they looked at. I've got a case where it is a restatement case, and they've asked for the accounting firm to produce all of their work papers and all of their internal analysis on looking at those issues. So it is going to be really interesting to follow.
I think Christian's, I think, going to talk a little bit about some governmental disclosure obligations.
Yeah, again, focusing again on sanctions, export controls, because that's kind of a hot area. The disclosure process in that area is, is something that you need to think through carefully, because there are some details underlying all of this. One of which is, you have the regulatory side, you've got the DOJ side. Each treats disclosures a little differently, and for example, with the Office of Foreign Assets Control or the Bureau of Industry and Security, once you make an initial disclosure of a potential violation, the incentive there obviously is to get credit. If there is an investigation and there's some type of resolution, that's going to factor heavily, potentially, in that resolution, whether or not that disclosure was made prior to an investigation, government investigation being initiated. So the question is, well, do you disclose early on, as early as possible? You think there may have been a violation, not sure, haven't had time to investigate, do we disclose? Versus do we wait and do the investigation? Maybe there's really nothing there, and it's a balancing act, because again, if you wait too long, the investigation expands, more people learn about it. Is that going to raise the risk that it's going to catch the attention of one of the regulatory agencies? Obviously, it depends on the type of violation and investigation, but I would say that generally would raise the risk. So in that case, it's clearly because there is a lot of weight placed on cooperation and early disclosure prior to an investigation being initiated. There's incentive there. And it doesn't it isn't automatic that they're going to investigate. There are cases where there's an initial disclosure, a company finds what they think is a violation, and they're allowed to investigate it, and it turns out that either there's nothing there, or they do a final report, it's detailed enough, the OFAC, BIS, or Commerce put a lot of weight on that report, and it gets resolved with essentially a letter, and there's no follow-up investigation. So that does happen. It's not like it's going to be an automatic investigation if you do the disclosure. But the one issue is if you have what you think may be potential willful conduct involved, and that's where DOJ would get involved. Someone knew that they were breaking the law. They don't need to necessarily know which law they're breaking, but they knew that they were committing a bad act. If there is any potential criminal exposure there, you need to sequence the disclosures, because if you say disclose to OFAC, DOJ is not going to give you credit for that. So you would have to do 2 separate disclosures to make sure that if there was a DOJ investigation, you're going to get credit for that as well. Along those lines, once you do disclose to, for example, OFAC, there's always the risk of a referral, that if they do take interest in the case, that they do a referral to DOJ. And if you haven't disclosed to DOJ by the time DOJ gets involved, you would lose the opportunity to get credit for that disclosure. So those are kind of some of the things to think about. It's obviously it's tricky. The timing issue is tricky, but I will say that because of the potential penalties, and in particular with OFAC, it's a per violation penalty. So if you're looking at somebody was doing something wrong, and again, the OFAC, think of it as more strict liability. There doesn't need to be willfulness there for there to be a violation. If you're involved in an industry or where there's a high volume of transactions, and you go back and find out either through some type of due diligence, someone finds out, oh my gosh, we've been doing this wrong. We've been actually, didn't realize that one of our customers is doing business somewhere that they aren't supposed to be, and there's been a number of high volume of transactions. Each one of those transactions can be treated as a violation, and you're looking at potentially $330,000 per violation, which adds up. So anyway, that's just a little bit on kind of the things to think about, certainly in the sanctions context, or export controls for disclosures.
Thanks. And we're just going to touch briefly on on 2 issues, so Susan doesn't yell at us if we don't get done here by 6:30. Jumping real quick back to the employment side on the investigation, one of the goals that I mentioned earlier was ensuring there's no retaliation against any whistleblowers or witnesses. The 2 things really to be here mindful of is make sure you know who is protected. There's a whole host of federal statutes and state statutes that provide protection for reports, certain reports, not others, but also some provide protection for witnesses. So it's important to know who is protected, and then make sure you're safeguarding if there's anonymity already and information related to them. Make sure you're counseling the people who know that they've done reports or that they've been witnesses about the company's policies on anti-retaliation, and that HR is involved to make sure there's no issues there. And then one other issue to really be mindful of that comes up almost every time we have the situation is there are certain statutes, the Defense Trade Secrets Acts, the SEC has a rule about this, that employees are allowed to disclose trade secrets regardless and not face any civil or criminal liability, as long as it is solely for the purpose of making certain protected types of reports. Well, there's been a fair amount of litigation over the last few years on that, where courts have broadened that protection, which we colloquially will call a whistleblower privilege, that employees can steal documents, steal data, and then claim that it was for the purpose of whistleblowing, and it makes it very difficult to Some of these cases make it very difficult to claw that information back. It makes it difficult to enforce rights under non-disclosure agreements against them. Lawsuits against employees in those situations can potentially be deemed to be additional acts of retaliation or acts of retaliation. So this is an evolving area of the law, but it's just something to be mindful of. And another reason why you want to have really stringent protections over your information to avoid losing it in the first place. And then lastly, I'm going to turn over to Christian and Jason to talk a little bit about privilege.
I think generally folks are pretty attuned to privilege issues, but again, a lot of this goes back to the type of investigation, who's running the investigation, so who's holding the privilege, whether this is a special committee investigation versus a special litigation committee investigation versus an audit committee or versus a company investigation. So always being cognizant of who holds that privilege and obviously offering the proper upjohn warnings when you're interviewing witnesses to let them know that you're not their counsel and who holds the privilege and who can waive that privilege, especially as they deal with government regulators. And I know we're running out of time, so.
Yeah, just on that point, talking about, in particular, running the investigations, if you're in multiple jurisdictions, you have to coordinate with counsel in the non-U.S. jurisdiction because the upjohn in the U.S. may not necessarily be adequate. In particular, I'm thinking of some European countries. And in some of those European countries where they may have a little more enforcement inertia, they're not going to honor the U.S. privilege necessarily if, for example, an attorney from their jurisdiction is not part of, for example, the interviews and part of those discussions that are the subject. So something to think about as well.
Well, thank you guys again. We meant to leave some time for questions up here, but we will be around at least until the show starts, and happy to talk about any issues or questions you all have. Happy to share the PowerPoint if anybody would like a copy of it. Just let us know.
This was your first opening act.
Right. Yeah. I don't think it's better. Thank you.